Good morning, everybody. Thank you guys all for being here. My presentation is going to be like a one-act play, and I'm going to be playing the roles of a judge, prosecuting attorney, defense attorney, and of course the expert witness. So with that being said, our courtroom will come to order. So you've each been sworn and selected to serve as members of the jury to try the case of the state of Florida versus Daniel Dawson. This is a criminal case, and Mr. Dawson is being accused of the crime of second-degree murder. It is your sole responsibility to determine if the state of Florida has proved its accusations against Mr. Dawson beyond a reasonable doubt. Your verdict must be based solely on the evidence or lack of evidence in the law that I will give you. It is the judge's responsibility to decide which laws apply to this case and to explain those laws to you. It is your responsibility to decide what the facts of the case may be and to apply the law to the facts as you find them. So, the province of the court and the province of the jury are well defined and they do not overlap. This is one of the fundamental systems of our justice system. Before proceeding, it will be helpful to understand how this will be conducted. First, there will be opening statements from the prosecuting attorney, then the defense attorney. In each statement, they will tell each of you which evidence they will be presenting. After that, there will be the actual presentation of the evidence, which includes the physical objects and testimony. Then we'll have the closing arguments, first from the defense attorney, then the prosecuting attorney. And after that, you guys will each deliberate and render a verdict. So now for the prosecution opening statement. Good morning, ladies and gentlemen of the jury. A Glock 21 .45 caliber pistol was purchased by the defendant, Daniel Dawson, on March 21st, 2010. We have the receipt of this purchase, and the firearm is also registered in Mr. Dawson's name. On the night of August 20th, 2014, the deceased body of Paige Pearson was found. At that crime scene, there was only one fired cartridge case found and collected. You will hear testimony from the expert firearm examiner shortly, saying that that cartridge case was a match to the firearm registered to Mr. Dawson. On the night of Paige's murder, we asked Mr. Dawson where he was, and he said he was out of town for the evening, but he has no alibi to prove this. So, where was he, ladies and gentlemen? That's easy. He was taking the life of innocent Paige Pearson. So now for the defense opening statement. Good morning, ladies and gentlemen of the jury. This is a sad case. A young girl lost her life. My client's life is also on the line because he has been accused of this crime. My client is innocent because there are issues with the facts that link him to that firearm. Mr. Dawson often leaves his home unlocked and has not seen his firearm in over a month. He thought he had misplaced it, but also suspected his nephew stole it and possibly pawned it off for cash. My client's gun might have been used to kill Paige Pearson that night, but he did not pull that trigger. I hope you can understand this and will make the right choice when deciding if he is guilty or not guilty. The prosecution would now like to call Ms. Catherine Hefner to the stand, who is an expert firearm examiner. Before she can give us her opinion, she must qualify to testify. Ms. Hefner, could you please tell us what you do and what qualifies you to testify? I'm a senior at West Virginia University in the FEPAC-accredited Forensic and Investigative Science program. Last year, I completed an independent undergraduate research project with faculty mentor Dr. Keith Morris. I was supported by the WVU Ronald E. McNair program. My objective was to determine if I can improve the interpretation of the evidence drawn from cartridge cases. For my research, 30 rounds of ammunition was fired each through 20 Glock pistols and collected for analysis. Here was a model of an unfired casing. The light-colored portion is the cartridge case, which is left behind at the scene where the weapon was discharged. On this fired cartridge casing, there is impression evidence that examiners use to determine matches. And there's two regions that examiners are interested in and typically use for their analysis. First is the firing pin impression, which is in the middle of the gray circle. And the second region is the breech face, which is on the outside of the firing pin impression to the edge of the gray circle. It is these two regions that examiners use because of the striations that you can see that are running parallel. They match these striations, and much like a fingerprint to an individual, these are unique to firearms. For my research, I looked at the firing pin and breech face area of the 600 fired cartridge cases, that was 30 rounds each from 20 guns, and validated the ability to use the firing pin and breech face areas to compare cartridge cases. An image of all 600 cartridge cases were entered into the Integrated Ballistic Identification System, or IBIS. This system is a tool that examiners use to compare cartridge cases that uses a mathematical algorithm to match the similarities on the head stamp. I then determined the discriminating power of IBIS's ability to determine a match. So what do I mean by this? If the discriminating power was found to be at 0.5, that would mean that the IBIS system correctly identified a match 50% of the time. So it is not very likely at this discriminating power that the cartridge case came from that firearm. But if the discriminating power was found to be a 1.0, that would mean that 100% of the time IBIS was correctly identifying a match. So for my research, we found that IBIS was determining the matches of 0.9 or above for most of the firearms, meaning that it correctly identified a match 90% of the time. For guns that had slightly more use, their values of the discriminating power were slightly lower, around 0.8, as might be expected. Because as the firearm ages, there are factors that decrease this discriminating power. The gun's use and care are typical factors that affect the striation patterns on the head stamp. If we incorporate the discriminating power of each piece of evidence, like a cartridge case, we can properly weigh the evidence. So in summary, my research has demonstrated that a statistical comparison using a well-defined mathematical algorithm in IBIS software will discriminate the cartridge cases from one another, and we can attribute these cartridge cases to its gun. As the judge, I find this expert qualified to render her opinion. Ms. Hefner, could you please tell the ladies and gentlemen of the jury what you concluded in this case? Using the Integrated Ballistic Identification System, or IBIS, I compared the questioned cartridge case to a database of both known and unknown cartridge cases. I found a possible match in the data IBIS generated. I then confirmed these results using a comparison microscope. This is the view seen by the examiner through the comparison microscope, and it provides the examiner with the ability to see two separate slides in one frame, separated by this hairline division near the middle. On the left, we have the known cartridge case, and on the right, the questioned cartridge case. And as you can see, the striations are aligning. From this data, I concluded that this cartridge case was fired by the firearm registered and owned by Mr. Dawson. The defense would now like to cross-examine this witness. In your opinion, did Mr. Dawson commit this crime? And all I can say at this time is that the cartridge case found at the scene matched the cartridge case registered to his name. Thank you. I have no further questions. Mr. Dawson, the defendant in this case, is being charged with second-degree murder. If you find that Daniel Dawson committed this crime, you will then need to render a verdict of guilty. With the limited information I've just given you in this brief court case, it's now time for each of you as members of the jury to determine if the defendant, Daniel Dawson, is guilty or not guilty of murdering Paige Pearson. So, have you guys reached your verdict? By a show of hands, who believes that Mr. Dawson is guilty? One. Not guilty? A few more? Okay. My goal today was to share with you the challenge that members of the jury are faced with in an effort to reach a decision. In our case, we have two hypotheses. The prosecution is saying that the defendant committed the crime, and then we have the defense hypothesis, or alternative hypothesis, saying that someone other than the accused committed the crime. And just like the scale, the members of the jury must determine the weight of each of those hypotheses to determine the guilt or not guilty of the defendant. This is a challenge. The field of forensic science is moving rapidly and using research to develop analytical methods to assist our system of justice. With more research, such as what we are doing at West Virginia University, analytical tools and statistically based explanations can assist the court when interpreting evidence. Evidence such as fingerprints and firearms can be partially subjective and rely heavily on the expert opinion of the trained examiners whose knowledge has been certified. As forensic scientists, it's our job to draw conclusions objectively. Understanding the variability associated with physical evidence is important. Drawing statistical inferences and establishing probability ratios help bring scientific rigor to this analysis. I'm sure that each of you has heard or read about a recent wrongful conviction and exoneration. Such convictions may have arisen from the inadequate use of forensic science. Today, using more contemporary analytical analyses, we have the ability to be more precise when discriminating our evidence. It is through programs such as the WVU Innocent Project, which brings our faculty in law and forensic science together to exonerate those wrongfully convicted through new analyses. For forensic science, this is an exciting time. We work in a discipline where basic science has a significant practical application to real life. I appreciate all of your time, and I would like to answer any questions you may have at this time. It's not that. Like, IBIS system's not changing really. They're starting to do more like 3D models of it versus the 2D that it is now and what I used. And that's just going to increase the ability for it to correctly determine matches because it is just a tool. You can't rely, unfortunately, on that. And that's what you have to, whenever the examiner has to verify with the comparison microscope, and you're inserting that subjectiveness into it. So IBIS is pretty standard. I mean, it uses what it uses. It's a computer, basically. So we can only use it as a tool, unfortunately. We can't use it as an actual system that determines the match 100% of the time. And with the gun's use and care and the type of gun, it can do that a little better for some guns versus others. Does that answer your question? Yeah, so unfortunately, some criminals are more intelligent than others, and they can manipulate the firing pins of those, and that would make it more difficult for the examiner to determine a match. Yes?
On a personal note, how did you become interested in this, and what caused you to sort of make this your
Sure. So whenever I was accepted as a McNair Scholar, they say, go pick your mentor. So I was a little nervous. This was my sophomore year that I was selected and coming to the end of that year. And I was like, oh no, like, what am I gonna choose? Like, I had just been accepted to the actual program and I hadn't had any examiner courses. So I had to make this decision quite blindly. And I thought, and I went to, it was the chair of the department then, Dr. Keith Morris, and sat down with him and scared, and I was like, oh, like, what are you doing? Like, you sound really cool, and like, you're awesome. And he said, yeah, he gave me some options. He was doing this with another project, and he's recently put in he's gonna publish this soon, not on my data, but on his data that used a lot more guns. But he was doing that, and then he said, you know, you can do fingerprints. And I was like, fingerprints? That sounds really boring to me. I was like, guns sound a lot more interesting, so that's how I chose that. And then where I'm going after that, I loved the statistical bases that we were using to kind of validate this. That was really cool to me. And even though it was like really over my head and the grad students had to like really help me a lot with it, I liked it because it was numbers. It wasn't it wasn't quantitative, it was more qualitative. It wasn't qualitative, it was more quantitative, and I liked that. Yes. McNair it's funded through the Department of Education. It's federally funded. It's a TRIO program, and it's for first-generation low-income students, and it's gearing you for graduate school and ultimately to get your PhD. So it was named in honor of Dr. McNair, who was in the Challenger explosion. So. I do. I think I'm standing here today because of McNair. The McNair program at West Virginia University is phenomenal. The director is amazing. She's done wonderful things. She's made wonderful connections with us, and she really cares about us. So that's made me being here today possible and really opened my eyes to what I can do. Yeah, so this year they started their LLM joint custody programs. So it was really combining the justice system with forensic science. So that was really exciting for them to start this year.
Can I add something to that?
Yes.
I was the dean of the law school, so when we started planning for the forensic justice program, and one of the things we based it on is the National Academy of Science about a decade ago, I think now, came out with this incredible report about forensic science, and its conclusion was that the science was far outstripping the knowledge of lawyers and the judicial system to actually use the science properly.
it's exciting. Like, I was talking to Dr. Lang, like how I could present what I did in my research project to you guys who are educated, but it was hard to relay that, and that's exactly what they do in court. So we have these expert firearm examiners, and they know what they do, and they know why it's a match, and they know how to tell you guys, but it's kind of telling you more effectively in a way where it's not just a match, or it's like, well, what does that mean? So educating the attorneys in that, educating ultimately the judges will hopefully help decrease wrongful convictions and uphold our justice system more appropriately. Any other questions? Yes.
What do you want to do next?
Oh, so
Long-term career goals.
yeah, so I'm graduating in May, so that's really exciting. I'm applying to everything under the sun. Thought about studying abroad, thought about joining the military, so it's all of these other things that you're thinking about, but ultimately I want to go to grad school, I want to continue my education. I'm going to do national security and intelligence, and I'm going to be applying to 4 programs ultimately in the DC area, and then 1 in PA, so Pennsylvania. And yeah, I want to work for the government and be an analyst, and that's where the direction I'm heading right now. Any other? Okay, thank you guys. Have a good day. Enjoy Naples.